In the history of inheritance law, there are cases where people attempted to control the future through unusual conditions written into their wills. Lawyers describe such clauses as conditional inheritance provisions. Sometimes these conditions were simple, but in some cases they became so unusual that they are still discussed in legal history today. One remarkable example comes from John Bowman, an American businessman who died in 1891. Bowman believed that he might one day return after death. In his will, he left money so that his house would continue serving dinner every evening. According to the terms of the will, the table had to be prepared regularly, and meals were to be served in case the owner returned. For years after Bowman's death, the dinner ritual continued. Eventually, the court stopped the payments, deciding that the condition had become unreasonable. Another unusual case appeared in Los Angeles in 1968. A man named Luis Carlos de Condon left $64,000 to his dog named Blackie. The money was placed into a trust, and a caretaker was required to use the funds exclusively for the dog's care. The case attracted enormous attention. The court eventually reduced the amount to $25,000, arguing that the original sum was excessive. Nevertheless, the story became one of the earliest famous examples of what lawyers now call pet trusts. Even famous historical figures sometimes left unusual details in their wills. When William Shakespeare died in 1616, his will contained a curious line. He left his wife what he described as "my second best bed." Historians have debated the meaning of this phrase for centuries. Some interpreted it as an insult. Others argue it may have been a sign of affection, since the best bed in a house was often reserved for guests. These stories illustrate an important principle of inheritance law. Through wills and trusts, individuals sometimes attempt to influence the behavior of future generations. Courts may invalidate certain conditions if they violate the law, contradict public policy, or become impossible to fulfill. In the history of wealth and inheritance, legal documents have sometimes carried instructions far beyond the lifetime of the person who wrote them. And occasionally, those instructions turn out to be stranger than anyone expected.